Hello, 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 hello. Good evening, good evening, good evening. Hi, everybody. Hey, 𝒍𝒂𝒍𝒂𝒍𝒚. I'm telling you, I think he is probably my number one supporter. I tell you guys. Hi, everyone. Let me adjust this a little bit. Hi, Facebook. Hi, Instagram. Hi, YouTube people. Hey, family. Come on in, come on in, come on in. Exciting news for VAWA petitioners. So if you don't know anything about VAWA, you want to know, hang around. If you know somebody who is in the process, this is awesome. Awesome news for VAWA petitioners. Hi, everyone. Good evening, wherever you are. So you gotta love, see, immigration is it's never ending. But you've got to love people who are willing to fight and put their own cases out there on behalf so that other people like, we immigrants can benefit from that. Hi, everybody. Come on in. Come on in. Say hello. Say hello. Come on in. Let's talk immigration. This is attorney 𝒊𝒎𝒎𝒊𝒈𝒓𝒂𝒏𝒕, immigration lawyer based in Alabama, representing immigration clients in all 50 states. So let's get right into it because it's almost 9 p.m. here. And listen, yeah, that's my life. I keep going. I don't think I cannot remember the last time. And I know this is not really because you're supposed to get like 8 hours of sleep. I tell you, I cannot remember the last time I got more than 5 hours of sleep. If I get 5 hours, that is more than plenty for me. But listen, that's the story of my life. But anyway, this is attorney 𝒊𝒎𝒎𝒊𝒈𝒓𝒂𝒏𝒕. If you need to contact our office, number is 334-341-4475. Visit us on our website at 𝒊𝒎𝒎𝒊𝒈𝒓𝒂𝒏𝒕. Sissy lawyer Neil, 𝒊𝒎𝒎𝒊𝒈𝒓𝒂𝒏𝒕, baby boo 1650. We'll get to the questions later on. So let's jump right into what we want to talk about. Summary of what we want to talk about tonight. VAWA. A lot of things. Well, good updates, good changes, effective immediately that will affect those who have pending VAWA cases or that will be filing VAWA cases effective today, February 10, 2022. If you have a VAWA case that is pending or you'll be filing a VAWA case, this is for you. Now, I know I have more than 10 VAWA cases that we currently have pending that needs to be out latest by the end of March for my clients. It is so refreshing when you're able to help people get out of miserable, emphasis on miserable marriages because they feel they have to depend on their, citizen or legal permanent resident spouse for immigration status, and those people show you hell. So it is a great thing to have VAWA as a tool for immigrants so you can gain your freedom. Nothing like it. So if you don't know what VAWA is, and if you need to contact our office, once again, the number is 334-341-4475. Hello, Facebook. Hello, YouTube. Hello, Instagram. Share this video. This is going to bless someone. I can guarantee you that. Share this video. Subscribe to your YouTube channel. Follow us on Instagram. Follow us on TikTok as well. So let's get right into it. Summary of what we want to talk about. What are the changes when it comes to proving the shared residency requirement in a VAWA case? How does a divorce affect a step parent or a stepchild, and are they still going to be eligible to file for VAWA? How does a previous determination of marriage fraud, let's say in the previous family-based petition, how will that factor into you self-petitioning in a VAWA case? And what will USCIS consider when you file? Summary of what we want to talk about. So VAWA is for, we'll get to the questions later. VAWA is for people who are, if you're an abused parent, abused spouse, abused child of a U.S. citizen or legal permanent resident. When it comes to abused parents, your son or daughter must be at least 21 and must be a U.S. citizen. There is no category for parents of legal permanent residents. For the most part in my practice, 99% of my VAWA cases are abused spouses. Parents issue just rubbed and wrong. And for children, they usually include it in their parents. And you can actually file for VAWA even if you're not an abused spouse, but your child was abused by your spouse, who's a legal permanent resident or a green card or a citizen, even if you, the spouse, was not the abused victim, you can also qualify for VAWA based on your child being abused by your spouse. So, effective today, February 10, can you tell I'm excited? One of the things, if you remember 2 weeks ago, 3 weeks ago, I can remember, but I put up a post that one of the most common grounds for denial of a VAWA petition is shared residency, the proof of shared residency. In a VAWA case, you have to prove that this is what VAWA is in a nutshell. VAWA is like a marriage-based green card petition. With the exception of your spouse, you put yourself in the position of the petitioner. So in place of a I-130, you replace it in I-360. In place of your legal permanent resident or citizen spouse, you become the driver of your petition. And you also remain in the seat of the beneficiary. So you basically control everything. And you control what proof you have to, what evidence you have to provide. However, because unlike a regular marriage-based application, both spouses have to be interviewed, the good faith evidence of VAWA lies solely with you. So you are solely responsible for proving that you have a qualified relationship, that is, you're married to a citizen or green card holder, or even if the marriage is no longer, you file the VAWA petition within 2 years after the divorce, that you're a person of good moral character, that your spouse is a citizen or green card holder or was, but due to the abuse, they have lost that citizenship or legal permanent residency status, that you have suffered abuse, you're physically present in the United States. So you have to show all of that, and that you live together with your spouse. Your marriage was in good faith, just like you would in a marriage space, and that you live together with your spouse. When you have a regular marriage-based petition, you're called to the USCIS field office with your spouse. If you do not attend with your spouse, your case will be denied. In a VAWA case, the whole point of that interview is so that they can verify whether you had the marriage in good faith and whether you live with your spouse. In a VAWA case, you do not have an interview for the VAWA petition. So everything USCIS is going to rely on is what you can provide as evidence of good faith and shared residency. Shared residency has been an issue. I have 3 cases, appeal cases. All 3 were denied based on insufficient proof of shared residency. One of the things that USCIS could not, prior to this case, and if you want the case law that actually was the turning point for this issue, where there are 2 cases, I can put that in the comment section and I can upload that in, and I'll put it on my website as well. But there was a lady who is Mexican, and she got married, and she lived with her husband. Just a summary of the case: lived with her husband. Well, one of the cases, lived with her husband before they got married, and then after they got married, she suffered abuse. Now, she filed for VAWA, and USCIS denied her case, saying that because she did not live, that she's trying to use time that she lived with the spouse before the marriage to qualify as shared residency. USCIS said no. That's what they've always said. USCIS has always maintained that your proof of shared residency must be when you lived with your spouse during the course of your marriage. That's been the controlling law, during the course of your marriage. Now, USCIS has basically, they don't have any option, based on the U.S. District Court's order in one of these cases, saying that the statute, meaning the law, Immigration and Nationality Act, if Congress intended for the shared residency to be solely restricted to the time that they got married, then Congress would have expressly stated that. But because the INA does not expressly state that it has to be during the course of your marriage, then USCIS can no longer interpret shared residency and limit it to the time that you were married only. So what does that mean in layman terms? That basically means that moving forward, from today, moving forward, any case that is still pending, if you have a VAWA petition, now if the case has been approved, this doesn't apply to you, at least for now. That's subject to change. But if you have a pending VAWA case, if you're going to be filing a new VAWA case, USCIS is now required to consider, when it comes to deciding shared residency evidence, they're not required to consider evidence that of you living together with that abusive spouse, abusive parent. Well, let's talk about abusive spouse, because parent, the marriage is there, then when a child actually benefits, and I'll talk about that. It's during the marriage, right? When they're not required to consider shared residency to include time that you lived with your soon-to-be spouse. So time that you were not married to that person, to the abuser, they're not required to include that, as long as you have proof that you lived together with them even before you got married. That changes. That is a game changer right there, because we've tried in the past. One of the cases that I said that I was retained to appeal, I don't know how that's going to, because that's been decided. But one of the things was, she tried, when she had an RFE, she actually included with her previous lawyer the fact that they actually were living together for at least 3 months before they got married. USCIS said, no, it has to be the time, shared residency, after you got married. So if you have a pending case right now, and you didn't have enough time or you have evidence to show that you actually lived with your abuser before you guys got married, you can now use that evidence. Okay, I think Instagram, can you hear me? I think I paused a little bit. You can now use that evidence to show shared residency requirements in a VAWA case. This is exciting. Again, I'm nerdish, I know, but this is great. So basically, the time you were dating and you live together, and you have proof that you live together, that qualifies as part of your evidence for shared residency. And that's something. You're so confused as hell. Okay, let me see if I can. I know I'm so excited. Tell me, 𝒊𝒎𝒏𝒕. Basically, in a nutshell, when you have to file, one of the things you have to prove in a VAWA case is that you live together with your abuser at some point. Let me say this: there is no requirement of the length of time that you're required to live with your abuser. You could have lived with the person for 1 week or 1 year or 1 day, as long as you live together, or 1 weekend, and you have proof to show that. In the past, up until today, USCIS has only accepted evidence of shared residency when the marriage actually started. So let me put it that way. When the shared residency requirement that they have accepted as sufficient evidence can only be after you got married to the abuser. Anything that happened, whether you lived together for 10 days or 10 months or 1 week, before you actually got married, they did not accept that as evidence of shared residency. Starting today, anyone who has a pending VAWA petition and anyone who is going to file a VAWA petition, I've contacted some of my clients, that has evidence of living together with the spouse before the marriage actually took place, that time is also going to satisfy the shared residency requirement. Does that take away the confusion? Say, Maxie, if you let me know. I don't know any other way to explain it. But that's basically it. They're including time that normally they did not include, which is prior to the marriage. Now, if you have evidence of living with that abuser before the marriage, that can be part of that. Not only can that be part of your evidence, perfect, okay. But if the only time you even lived together was prior to the marriage, that is sufficient evidence. As long as you have sufficient evidence, that satisfies the shared residency requirement in a VAWA case. Hello, right? Okay, that's that. So if you know that you have evidence pre-marriage, then you want to add that. And if you see a couple of my clients here, so if you know you have something, and you probably got emails from me that you can add to your case before we send it, or even if they send you an RFE for that, then you can add that as time that you live with your abuser before the marriage as your part of your evidence for shared residency. Exactly. Because I know a lot of people who actually, live together longer before they got married than the actual length of time they live together after the marriage. So now that's not irrelevant. That is going to be part of evidence that the U.S. District Court has said they've got to consider. That's awesome. Okay, what else about this new updates when it comes to VAWA? So let me stress again. If you remarry when your VAWA case is pending, your case will be automatically revoked. Keep in mind one thing. If you remarry and you think USCIS is not going to find out, understand something. They research, they understand, and they will pull records. Like the U.S. government can pull records from any state when it has to do with the national interest. So let's say you got married, 6 months before your VAWA was approved, they approved your VAWA, didn't say nothing, you went for your green card interview, everything checked out, they didn't ask you nothing, you said you're not married. If for whatever reason, they're able to get evidence that you were actually married before your I-360 was approved, they will automatically revoke your petition. Meaning, if you've now attained green cards, you have your green card, and say for instance you're applying for naturalization, and they backdate because they can go as far as they can. They'll tell you 5 years, but that's case by case. That's what it is. And they see that you were actually married before your I-360 was approved. That means you did not qualify for your green card, and they can revoke your status. That's just the way it is. So you cannot remarry while your VAWA petition is pending. Number one. This is where it gets different. Stay with me here. Now, if your VAWA I-360 has been approved, meaning the VAWA petition itself, people always say, okay, I'm filing for VAWA. When is the green card interview? Keep in mind, the way it works is this. Even though you file everything at the same time, especially because you want to work while that is pending, your I-485 is just doing nothing while the VAWA case is pending. The only thing that you gain from you filing your I-485 is being able to file a C9 category work permit, as well as file an advanced parole so you can travel while your case is pending. But the I-485 just sits there and is waiting for the VAWA, because the I-485 is not a standalone application. It's got to be attached to something. In a VAWA petition, it is attached to the I-360. But the benefit that comes with filing that at the same time is that you can get a C9 category work permit and work. So it sits there, and your I-360 now is being processed. When the I-360 has been processed, it's been approved, Vermont Service Center forwards your entire file to the field office in your state of residence. Then your field office now starts to adjudicate your 485 based on the fact that the underlying petition, the I-360, has now been approved. So if you get married before the 360 is approved, that nullifies your petition. Now, stay with me here. If you get married after your 360 has been approved, but before your I-485 interview, the green card interview itself, you do not risk losing your VAWA status, because your I-360 has already been approved, even though your green card is still pending. If I lost you there, just let me know. I'll leave for this. This is my life. Okay. I hope everybody understands that, right? Now, let's talk about remarriage when it comes to children. Children. If your child is under the age of 18, and a child is a stepchild, a divorce from the parent, meaning so the abuser has a stepchild, you get divorced, so now your child no longer legally have a step parent. However, the stepchild will still be eligible to file for VAWA as long as that child is under the age of 18 and that child, the abuse happened at the time that the marriage was still valid. So the relationship, the step-parent, stepchild relationship actually existed at the time the abuse occurred. Even if there's now a divorce, the stepchild will still be eligible for VAWA. Gets better. If a stepchild gets married while an I-360 is pending, and child means child by immigration definition. If a stepchild gets married or a child gets married while an I-360 is pending, it will, just like an adult, it will nullify the I-360 petition because there is no category of married children when you got married, and there's no category for that. However, if that stepchild now divorces while the I-360 is still pending, but they get married and now they're divorced before the I-360 is approved, then they retain their eligibility for VAWA. It's not the same as the abused spouse. You don't get that chance that a child gets. I didn't make the rules. Okay. And I think this is the final point that I want to talk about tonight, and I get to the questions. I currently have cases of clients who have already been, and I'll tell you why I do that, who have already been determined, or it's been concluded that their previous marriage was just solely marriage fraud solely for immigration benefit. It was a sham marriage. And that permanently bars you from being able to adjust your status and get a green card. But the thing is this: the only way you can rebut that is filing yet another petition that gives you an opportunity to defend yourself. And so I currently have a guy who went through hell with his first marriage, and she messed things up and actually said he got married for a green card, and they concluded he was for green card. He divorced, got married to someone else. He has a child with this person, going through even worse hell, if there's anything like that. But he's got a prior indication of marriage fraud. And I said, you can either just sit down and accept that, or you can use your circumstances right now, because you literally, like, it's hell for him. I'm not even kidding you. And file for VAWA, because you get the opportunity to rebut that prior conclusion of marriage fraud. Now, with this new updated policy manual, in the past, they would only base the fact that, okay, no, you're not eligible to file for adjustment of status or qualify. You're not going to be able to prove the good faith requirement of VAWA because you've already been indicated in the previous matter of marriage fraud. Now, USCIS will be required to send you an RFE or notice of intent to deny if you have already been indicated of a previous marriage fraud in the previous filing, and they cannot base their denial solely on that previous case. They would have to make a new and separate determination that you indeed were indicated and guilty of marriage fraud, and now you'll be given a chance in a notice of intent to deny or request for evidence to rebut that presumption. That is awesome. I'm telling you guys. I'm telling you, it's awesome. So this is just like, okay, if you're being on the fence about, well, I lived together with them, but that was when we were dating, or I've been indicated of marriage fraud in the past, but yet I'm going through abuse, but it's worth a shot. What is the worst that can happen? You get a denial. What's the worst that can happen? They'll put you in removal proceedings. You can't just get into immigration court and then they put you in a plane. Now, well, they do expedite removal, but not in a case where you have an NTA. NTA means you have your day in court. So it is worth a shot. Don't stay in an abusive marriage and feel depressed and feel like you've got no options, or previous marriage failed, and now you feel like you have a life sentence of, well, they said I was involved in marriage first, so I can't win this time. No, it doesn't work that way. So you've got to fight. Listen, you've got to fight. What you got to lose? Nothing. Well, yeah. Okay. All right. So let's try to give me 1 second. Let me. Okay. I don't think I can get to all the questions. I will try. So let's see how fast. I'm going to start on YouTube and Facebook. Good evening. Good evening. Good evening. Good evening to everybody who says good evening. Good news so far. Exactly. Favorite immigration lawyer. Thank you. I accept the rules virtually. My day was absolutely productive, busy, but I can't complain. Is VAWA still possible after 11 years of divorce with 5 kids? No, you've got to file for VAWA within 2 years of the marriage ending in divorce. How do you prove shared residency? Shared residency, photographs, shared residency and good fit are almost like intertwined, because shared residency is you've got meals coming to the same place, you've got affidavits of people who knew you, you've got photographs of people visiting you in your home, you've got, and keep in mind, shared residency is almost the same thing. Your evidence would be very similar. It just means that you live together. Shared residence is different from good fit. Good fit is your intention of having that marriage last. Shared residence is you were roommates. I hope that makes sense. That it's not like anywhere, but that's how I can explain it. So bills, lease agreement that you're both on the lease, that you have photographs of people who visit you, you have neighbors who can say, yeah, oh yeah, they both live in that place. You have cars that you can take, your cars are parked in front. Anything that can prove that you live with that person, or you lived with that person for a while. Photographs of you moving nights, not just one night where you're wearing the same thing, different nights, let's see, things to that nature. Those are examples where everybody's case is different. Whatever you can use to show that you lived with the person. Okay. What if you have kids and they found out? Kids has nothing to do with it. If they found out you have kids, that's no remarriage. It's nothing in the policy or in the law that says you cannot have kids with somebody else. It just says you cannot get married while good evening, Miss Pam, while your I-360 is still pending. Keep in mind, if your I-360 has been approved, but you get married before your 485 is approved, that does not nullify your petition. I entered without inspection and placed in removal and seek asylum. Later got married 2 years, and then she abused me after. I just request for administrative closure. Good as is. I hope everything works out. So you're still waiting on the administrative closure, because keeping in mind, entry without inspection also is one of the things that is exempted when you file for VAWA. Okay, can I travel out to U.S. with travel parole after granted? Administrative closure does not terminate proceedings. So if your administrative closure just means they're taking off their active docket. So I don't think you will be able to get a travel parole. If your case is, if proceedings are terminated, then that means jurisdiction reverts back to USCIS, and at that time you can apply for advanced parole. Alice Lickens, can I withdraw my asylum case after marriage? You can, but what I always say is, rather than withdraw, tell them to hold your case, because if the marriage doesn't work, hopefully marriage work, but if it doesn't work out and your asylum case is adjudicated and then you're placed in removal proceedings, that's another ballgame. So you can, but just know when to do it. Ma'am, can you please tell me about DACA and Nichelle? It's still not being accepted. Love your videos. Thank you. What if you've got kids during VAWA and they found? I just answered that, Ms. Zanik. Okay, such a wonderful lady. You totally explain everything that is basic about. Thank you. I try. So if you guys don't know, I used to be, listen, I've been everywhere. So I used to be an adjunct professor. I still have some of my past students who would email me, but I used to be an adjunct professor of business law. I taught business law in one of the universities here, 4 years. Yeah, but life got busy and I just couldn't do it anymore. I could not. So I had to stop. But I think that's why I am able to, because I had students that I had to explain things to. And for me, my thing is, I need to And that's the way my brain works. I don't care the amount of grammar or English or whatever big words you have in something. If I cannot understand it, it doesn't make any difference. So I try to explain when I read something, I try to explain it to myself. If I can get it in very, very simple terms, then that's the way I try to explain, because nobody cares about the big legal jargons. What the heck does it mean? That's all everybody wants to know. What does it mean? Okay. What benefits can one apply for with prima facie determination? I did that video last week. So if you go on my page, whether it's YouTube, Instagram, you would see there. So it's very, very lengthy. Can I apply for 495? You mean 485? Yes. If you, obviously for you to apply for VA, you were married to a citizen or green card holder, and F2A is current. So yes. Naja, Holy Spirit, Lord. I'm telling you. Listen. You've got to believe in something. And for me, it's God. You've got to have something, a power that's higher than you are. And for me, that's how I was raised, as a typical Nigerian girl, raised in a Christian home. And I used to be a member of MFM. Not by choice. I was forced into it when I was married. But there's some things I still took away from it. And there's some prayer points, like the prayer points. I don't like all those snake prayer points and all of that, but there's some prayer points that I still use. Hello, man. My mom married this man since 2019, refused to file for her. She needs to consult with an immigration lawyer. This is one, but even if it's not me, consult with an immigration lawyer, see what's been going on in the marriage. If it's a control issue, control is part of extreme cruelty. Can you apply for the transfer when you get that approved? You would need to apply for 485. Because with just the VA petition, you get what we call a deferred action. That means you will not place you in removal proceedings. So, okay, I have been denied before in the past for lack of evidence. I'm trying to file for VA this time. What are my chances? That's something you would need a proper consultation for. Chances are not something you discuss over, live YouTube or Facebook consultation. Okay, let me go to Instagram. If I don't get to your questions, please bear with me. It is a Thursday night. Just came back from picking my youngest kid from soccer practice. So, okay. Hello. Hope you're good. I am good. Thank you. Let's see. Cecilia Neo. Okay. Can you tell I'm excited? Because I just love when I can tell someone, okay, we can use that evidence when you told me that. And the thing about this is this. Every single person who has consulted with me, that's just the way I love to know the story, your story from beginning to present. So everything starts with, and a lot of people jump on the consultation, especially when you pay for 30 minutes. And the consultation, by the way, is $130 for 30 minutes, $230 for an hour. If you retain our services within 15 days from the consultation, you get a credit for that. So everyone wants to get, say, hey, let me just maximize my time. But I love to know your story from the beginning. When did you come in? Tell me your immigration history and how we arrived here. So one of the things I've always asked is when it comes to marriage base, especially for marriage base, if we don't have enough, because I have a client right now, we don't have an interview yet, but they don't have anything to show for good faith and all that, because the guy they won't put his name on anything because he has no social security number and he's got no other form of ID besides his passport, and just lives in a place where they just won't accept that. So part of what we use is the text messages and photographs way before the marriage and up until the marriage and now. So even in VA cases, when I consult with clients, I say, tell me about the history before you got married. And I've always done that. So now I can go back and I take notes during consultation. For every single consultation I take notes. So I can go back and say, you told me, this happened during the marriage. Can you get me any evidence to show that? So it's just good to know that, Good evening, Lucky Tom. All right. Hello. All right, let's see. Oh, I don't want to miss anybody's question, but I'm going to have to go through it so quickly. Working in healthcare and my I-765 is pending. Call them, send in a written expedited request. Oluwa Yimika, you said you're lost. tell me what you're lost about, and I'll see if I can say that real quick and not make you lost. Let's see. Okay. After getting prime approval on Vawa, how many days a week does it take to get EAD? Prima facie determination has nothing to do with when you get your EAD. Prima facie is just saying that they've reviewed your case and we're still working on it, but based on face, prima facie in English means on face value. Looking at it, can we check this out? If we can check all the requirements, okay, yes, we can send you prima facie, but then we will take time to examine every single requirement and see if you provided enough evidence to support that. It has nothing to do with your EAD. Okay, let's see. Sister lawyer, please, my mom married this man and they got married. So I think you're the same person. So how are you on Instagram and I know that's technology, but how you on? You're watching me on Instagram and Facebook? Okay, I ain't mad at you, but Becky's Closet. I think I just answered the question, right? Your mom needs to find out if she qualifies for VA so that she's not feeling like she is being controlled and at his mercy. Listen, VA is for you to know that you don't have to be dependent on your citizen or green card holder spouse because of your immigration status. I cannot tell you the kind of stories I have heard. I'm telling you. I can't even begin to tell you. But okay, someone's actually texting me on and said I'm watching you right now. I just text because my office phone is an internet phone, so I can get text on my computer. Listen, my law firm is a walk-in law firm. Like COVID taught us to be virtual, and I just had to find a way to still keep going. And right now, I can run my business from anywhere, really. Okay. All right. You say you're watching me. So just send me an email. My email is aos@olalayLawFirm.com. So someone says, okay, whenever people text our office, like, am I chatting with you directly? No, you're not all the time. It may be me, may not be me. Usually if it's me, I put my name there. Sometimes I do not, just because I don't feel like it. Or you've asked me that question on Instagram or whatever, you're not as no. So it could be anyone in our office. It could be Grace, it could be me, it could be a virtual assistant, it could be anybody. The only place I can guarantee you that I'm the one responding is my email, because that's my email. No one has access to my email. AOS, that stands for Abisola Olale Samuel at olalayLawFirm.com. So if you send an email to that, then you will always get a response. But that's my email. No one has access to that. I want your number so I can call you tomorrow, 334-341-4475. And let me let you know, if you call me, you will need to set up a proper consultation. This is my free information, free advice. If you need a one-on-one, you will need to set up a paid consultation. No ifs, ands, or buts. That's just what it is. Okay, so number is 334-341-4475. Say Maxie, I think we've already cleared out that you're no longer confused. Please verify that for me. Okay, you did. Okay, yeah. Okay, good. This is a relief. I know. My I-765 renewal is pending and I work in healthcare. What can I do? You can expedite that. They've actually put that out since last month. Expedite if you work in healthcare and provide evidence that you actually do work in the healthcare industry. And what I do is I call, but I usually, if you retain my services, what I first will do is to send in a written with evidence, because they don't, if you're not my client, they won't have my G28 on file. So they tell you to call, but I always send a written request with the evidence. Then once time has passed, when I know they should have updated your record with my information, then I call. If they still haven't done that, what I do is just call my client and tell them, hey, I'm going to include my client, have a 3-way call, and then we can ask what we need to ask. Okay. I work in healthcare. Okay, I already answered that. If you already filed C31 category, how can it be changed to C9, please? You would have to file, Bobo, you would have to file, I call my youngest kid Tush Bobo. Tush Bobo. His name is Toshi, Oduwa Toshi. I love that name. That means God is able. And my oldest is Oduwashi. God has done this. You've got to have God or something. That's just how we do Nigeria, right? So you would to qualify for a C9, you would need to file a 485, meaning your green card application. Okay. Let's see. I have a question, please, man. How many percentage of I-750 are being denied after interview? I can't really answer that question because I-751 depends on, is it a joint filing? Is it a waiver base? So if it's waiver base, is it a good faith marriage and a divorce waiver? Is it a good faith marriage, abuse waiver? Is it extreme hardship? Is it death? It's just, so there's no percentage. Can one who has NTA but no date yet who filed for eligible for work permit? So I just sent out to today where if you're already, that's hard because you don't have a date, so you don't have, well, if you don't have a date on your NTA, meaning if you believe based on a case law, if you believe that your NTA may be defective, then you want to consult with an attorney and see if you can't actually file for them to recall that NTA because it's defective. So you've not properly been placed within the jurisdiction of EOIR, meaning immigration court. And if EOIR doesn't have jurisdiction over your case yet, that means USCIS will still retain your jurisdiction. And so you may be able to file a 485 and then file a work permit. When EOR gets jurisdiction over your case, you can file your 485 before the immigration judge. And then once it's been properly filed, file your work permit with a copy of what you 485 you filed, file your work permit with the Texas Service Center and with USCIS. And that will be those will be your options. What could be evidence of shared residence if a spouse couldn't get on the list? At last resort, affidavits. Go knock on your neighbor's door and say, hey, you remember when I lived here with Abisola? Do you remember that Abby girl? A lot of people call me Abby girl. Listen, it's US. I remember when I lived here with, yeah, I remember you. Would you be willing to write something on my behalf and ask them, hey, would you be willing to give me a copy of your identification? I know I'm asking too much, but listen, my life depends on it. You've got to do what you got to do. So at last resort, and because you can put that in your personal statement is also part of your credible evidence that this is when we live together. This is what we used to do on Saturday nights. This is where we used to go. There's a photographs we took in the patio. But I don't have anything because he or she refused to put my name on the list. Would not put my name on the utility bill. Whatever the case may be. You've got to come up with, photographs you took in front of the building, the management office who knew that you were a tenant in that place and you lived there with your spouse. You've got to come up based on your specific case. And this is HRM Deji. Okay. Let's see. My wife, my wife, she is. Therefore, student, how do I change her status and what are the form need to print? You can set up go to uscis.gov and see what you need to do to change status. But that is something that will be discussed in the consultation. So I can't give you information that you would need to sit with me and ask specific questions. What happens if you've been separated with your spouse for over 2 years and she just had a child with another man while still married? What do you mean? What happens? What is the question you have? Okay, so I've already answered that question. Hey, Mr. Sunny, how are you? How long does it take to get your EAD card after you get your prima facie determination? And can you use that as well to get a renewal? Okay, so my battery is low. Hold on, that's on my computer. Work with me here, people. Wait. Let me get my battery. Let me charge my computer before I lose power. So I said that earlier that your prima facie determination has nothing to do with when you EAD. They're not. They just have nothing to do with one. Doesn't have anything to do with the other. And one of my dearest clients got his EAD delivered today. I'm telling you, the power of speaking things into existence, that I believe so much in that. Power of life and death is in the tongue. You've got to speak it into existence. Listen, the Bible cannot be wrong. This guy, we filed his case mid-April. He said, and I still have cases that were filed in January, February. January, we already sent requests, letters in that it's outside normal present time. But February, we're still waiting. They haven't gotten to March. But he said to me, he says, my EAD is going to come way before it's time for them to start working on cases in April. And I told him, like, I joined my fate with yours. I won't argue with you. I'm just, because I so believe that man proposes, God disposes. See, our ways are not his ways. Our thoughts are different from his thoughts. When God decides he's going to accelerate your case, who's anyone? Who's USCIS to decide otherwise? But I'm telling you, when we got the notification, like, listen, he spoke it. I agreed with him in faith, and here we are. So EAD has, and he's gotten his prima facie since, oh Lord, it's got nothing to do with EAD. No. So can you use it to renew your license? So there are some states that will allow you to, in one of my clients actually just emailed me today that she finally got her driver's license solely in California, solely based on being able to show that she's got pending cases. All she took was receipt notices and her passport. Every state is different. Then I have another client in, is it Oklahoma? That a prima facie determination would not even allow them, was not enough for him to get a driver's license. Every state is different. So you've got to find out what it is that your state accepts. How long does it take to get EAD card after getting? Okay, I've already answered that. Okay. I should already answer that. I used to fast it for 4 days. Not sure I would reckon. Are you talking about? No, don't come at me now. Don't come at me. I'm just telling you what my experience was at MFM. I'm not condemning the church. Don't get me wrong. It's just not a church for me. But I was married, and I went to that church because I was married to someone whose parents were pastors in the church. And I have done the deliverance before. And let me tell you something. I still fast, but that just, when I think about it, and see, I love my food. And I think that's where my issue is. Don't play with my food. Everybody who knows me knows that. So not being able to eat for 72 hours. This happened almost 22 years ago. But I still remember like yesterday. Because I just, no. But hey, listen. That's all I have to say. What are the questions to expect during my 10-year green card interview? We can go through that if you set up a proper consultation, or you can go through one of my videos. I already did a video on that. Can someone divorce immediately after I-360 is approved? You're not required to stay married while your I-360 is pending. Once you file, if you get divorced, that's fine. Now, if you're divorced, you can still file, but you have to show that the abuse was part of why you got divorced. But you're not required to stay married. So there's nothing that says you have to stay. But I've said this in the previous video. It pays to stay married just in case. If you have no hurry to get, unless you want to get, you can't even get remarried. But it pays to stay married just in case you need to refile your case. If you need to refile and you've been divorced more than 2 years, then you have no case, Okay. I'm waiting on that too. I hope it goes well. I work in healthcare. Okay, so I already answered that. What could be evidence for? I already answered that. Had interview since December 2020. Still no reply. What can I do? Oh, by the way, so the ombudsman inquiry we've always used for delayed processing at outside normal present time, they've now decided they're no longer going to be doing that. Yeah. So now, just cases that involve solely delayed processing, they will not get involved with that anymore. Listen, I don't know. How can I expedite my I-765 with Vawa filing C9? I mean, you could try the healthcare basis and see if that you can try that. Or if you have extreme financial hardship for you, that could be a basis. Can I change my name before becoming a U.S. citizen? Yes, you can, but just make sure you know what name you want on your certificate. I recently filed for Renewal. Do I still have to file tax jointly with my wife while I wait? I filed jointly during the 2 year. When you say you filed for 751 renewal, there's no 751 renewal. You mean you filed your 751. And if you're going to be if you file jointly and your wife is going to be at the interview because that's what's required, why would you not file taxes jointly so that you can booster your evidence? And for NTA, okay, I already answered that. See Maxi. Let's see. I wish you the best. Oh, I love my people. Y'all just nice to one another. Listen, I have zero. I can tell how many people have blocked on Instagram and Facebook, and zero tolerance for negativity. I'm a strong believer that the energy you surround yourself with is a big part of success in life and a big part of the positive energy you draw in. If you're constantly around people who don't ever see any good or complete haters, and they're always complaining about something or finding fault about everybody, you will become, what is that? And don't laugh. What is that proverb in Yoruba language where or something, right? Basically meaning, what if you leave a leaf on a soap and it stays there for so long, eventually it gets really soapy and you think it's soap. You become what you surround yourself with. And so for me, I'm someone who is happy when I see other people prosper. And I tell you, when I get an EAD or even an approval or prima facie determination, something to rejoice with a client, it's a celebration, because I know it is one step in the right direction. Even when we get a denial, every immigration lawyer under the sun has got a case denied. So don't let anybody fool you. But I always tell my client, okay, let's take, because I don't like losing. So it just sets me back. But then the next is like, okay, what's the game plan? You've got to find something where you can just bounce back and find something positive to keep you going. So I love when you guys are, supporting one another. Thank you. I don't think it says you can choose to file separately. But the thing is, if you're trying to get as much evidence for your 751 and you're filing jointly, they're going to ask you during your interview, so why did you decide to not file it? Now, if one person is paying child support and you don't want your tax return to be garnished, I mean, they're going to ask you though, that's just me. Exactly. It's just always advice. If you're filing jointly, why are you filing your taxes separately? Apart from Sister Lawyer, there's a lot of lawyers here tonight, though. Okay, I didn't know that. Okay, unlimited favor. Listen, someone consulted with me, and they went to. He said, "Well, I used to be a lawyer. I went to law school in Nigeria." Like, let me stop you right there. You didn't used to be a lawyer. You are a lawyer. You are a lawyer. The fact that you're not licensed in the United States does not diminish the fact that you worked hard to pass law school back home. You just have not become licensed yet. Don't let nobody tell you you're not anything. Because I've been told before that my law degree wasn't nothing and my place was in the kitchen when I was married. And I took that and I said, from my mouth to God's ears, I say, you're going to use me to bless people in this field that you have chosen for me. I don't know how you're going to do it. And that was before I even took any state bar. I don't know how you're going to do it, but you're going to do it. So not only did I pass the Alabama bar on the first try, I passed the New York bar on the first try. Not anything to my credit, but because God alone would take all the glory. So don't let nobody tell you you're not a lawyer, even if you're not licensed yet, because it's just a matter of time. Just a matter of time. Nobody's better than anybody else. Good evening, Miss Ronke. How are you? When will I be eligible for citizenship after 10 years green card? Depends on if you're still married to a citizen and you have satisfied the 3-year requirement. If you're not married to a citizen, then that'll be 5 years, and you can file 90 days before the 5th anniversary as long as you're satisfied, good moral character, continuous residency, scheduled for an interview, petition, condition. Don't understand that. Okay. And what happens when neighbors are all new occupants? I can't help you. I can't help you. I'm giving you the listen. After submitting I-485 and 765 was filed with C-31, how can it be changed to? So if you filed, and I know a lot of people make that error because when you go through the categories and you choose what category is for VAWA self-petition, it would say for 765, it will say C-31. But the C-31 is issued to you automatically when your VAWA petition is approved. You will not get a C-31 while your VAWA is still pending. If you want one while your case is still pending, since you filed a 485, you don't have to do anything but to file another 765 application for employment authorization and add that to your 485 receipt notice and your VAWA petition or I-360 receipt notice and send that to Veteran Service Center, specifically choosing C9 category in your form. That's all you need to do. Our pictures were deleted from film by my husband. I just feel I have no chance. Don't give up. Listen, I don't believe. What's the worst that can happen? You get a denial. But don't give up before you even fight. Don't accept defeat before you even start. See, that's just how my brain works. I just don't know how to quit. I just don't know how to quit. Now, I have something in my personal Facebook that says quitting is not an option, but sometimes letting go can be mandatory. But it's not in cases like this. I have submitted for 12 months. I haven't received nothing from them, not at all, just my receipt. Please, what can I do? If it's still within normal processing time, then you got to wait unless you have grounds to expedite. I got married in 2017. I got to go, people. After wedding, I got to know my wife had a burglary case. She refused to live with me where I'm currently working, and she keeps threatening. She wanted divorce. What can I do? If you've never lived, listen, someone consulted with me today and said, well, a lawyer, well, I don't know if these, but that's what it said. A lawyer told me that I can go file a restraining order and just so that I can have evidence. I would never tell you to make anything up. That's just me. And I told someone, I can't tell how many people I just cannot put my license on the line and say you live together after you have just told me you did not live together. So I know a lot of people feel more comfortable, especially because my clientele is mainly West Africans. And like, hey, this is lawyer, I'm powerful. I always tell you, let me stop you there. There's some things that you tell me that will make me unable to help you because my license is that more important than anything, camaraderie. That's just what it is. So if you've never lived together with your spouse, that means you've never shared residence. You cannot, in good conscience, go ahead and file for VAWA. You've got to live together at some point. It is a mandatory requirement of a VAWA case. That's just what it is. Okay, so, all right, people, I have to go. How long does it take for VAWA approval to be approved? So VAWA can take anywhere from 18 months to 3 years. I'm going to go back on Facebook and YouTube and see if, my cousin was denied the first time since 2019, waiting for second interview since then, but separated with the wife in January 22 while waiting for second interview. Can he put in for VAWA while second? So if he can satisfy, shared residency, good faith, abuse, good moral character, qualified relationship, physical presence, then that's something he wants to consult before he's scheduled for a second interview. If he is going through something that he wants to request that they don't make a decision and hold his 45 in advance, sometimes they would deny that, and then all he has to do is file a new one. But if he's already separated and he knows his wife is not going to go and he has basis filed for VAWA, then he needs to do that before it's too late. Anyway, okay, everybody. I wish I can answer all the questions. I cannot possibly, because I'm looking on Facebook and YouTube, I have 23. I can't possibly do that. If you need help with your case, contact us. Once again, number is 334-341-4475. This is what I live for. I have worked this path, not the VAWA path, but I've worked this path in the sense of I can relate to immigration journey because I've been in a situation where So I've never been out of status, so I can't say yes, I know, but I know what it feels like to be almost out of status. Now, I can't, I won't even say I was never out of status, but I've been in a position where I'm waiting. I filed, I think it was my very first H-1B that was filed, but I was waiting out way past when my I-94 expired. Being on a J-2 visa, subjected to these 2-year home residency requirement, ended up in an underserved rural health area. I get it. So when you see me so excited and just with my gray hair, it's because I tirelessly want to help others. And if I can make your journey just a little bit easier than mine was, or even just try to make it easier for you because mine wasn't that hard, that's my reward. But thank you all for joining. If we can help you, once again, 334-341-4475. Share this video with people because I know that a lot of people would benefit. And if you need one-on-one, then you would have to pay for my time. So anyway, thanks everyone. And until next time, you all have a good night. I may pop in tomorrow. I don't know. We'll see how tomorrow goes. But until next time, bye-bye.